I'm going to call this hearing to order. It's a hearing of the House Aging and Older Adult Services Committee. First, I'd like to ask you all to rise for the Pledge of Allegiance. I
pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you all. Just a few quick notes. If members and all guests would take, a moment to silence your cell phones so that they don't disrupt the testimony that we're going to have today and question and answers. So if you could silence any of your cell phones and electronic devices, I would appreciate that. Also, the audio today, usually we have a speaker that my microphone is on right now. Testifiers, your microphones will be on all the time, so be careful what you're whispering to each other. No, I'm just kidding. But our microphones will be off, and you push to put them on. Usually we have a speaker, so right now when you hear my voice, people here cannot hear any amplification or anything like that. But we still need your microphones on here at this table for the audio recording that our fine gentlemen over here are doing as well. So just so everyone's aware, turn on and off your microphone as you need it. So I called this hearing today to discuss the important issue of elder abuse in the Commonwealth. I'd like to just take a quick moment to thank New Hope Eagle Fire Company for their hospitality and welcoming our committee here today. Please join me in thanking them. I'd also like to thank our host state representative, Wendy Thomas. Wendy, thank you for hosting this committee here in your district. It's important that we have active, interested members, and Wendy was among a lot of members that have stepped forward since I became chair at the beginning of the year and offered their time and expertise and services. I want to thank you, Wendy, for hosting this event here in your district. Of course, I support and appreciate all of our members who have made the travel to be here today. This is a very important issue here in the Commonwealth, and it's imperative that we take every step possible to protect, really a group of our most vulnerable citizens. The people who, took care of us and got us to this point are now our seniors and hopefully living their golden years, and their protection is of utmost importance on my mind. There's been much headway over the past several years with my friend and colleague and Democratic Chair Steve Samuelson. The Democrats and the Republicans have worked together through the years that I've seen to help and address this issue, but there's still much that we need to do from a legislative standpoint. So today, we want to provide an overview of pending legislation in our committee and hold a panel discussion of these stakeholders that have come here today to discuss the issue and the bills before our committee. So with that, I just would like to introduce our executive director for the committee, Shannon Walker. She's right here to my right, and she'll provide a brief summary of the bills in two of the bills, well, probably more of the bills, right?
Three,
you have
unless you
three?
want me to talk about yours.
Yeah, no, yeah, there's one of mine as well, but she's going to give a brief summary of the bills that we're going to be working on in the committee. Shannon? Oh, yeah, you know what? Should I do that? Why don't we, thank you, Chairman. We should have everyone, all the members, introduce themselves, your name, your district, and maybe your time served on this committee or whatever else is of interest to you. Go ahead.
Representative David Rowe from parts of Union and Snyder counties up in central Pennsylvania. I am the highest scoring member of the House, number 203 out of 203, so I'm the new guy here.
Steve McCarter, House District 154, Eastern Montgomery County, and I think I've been on this committee since Steve Samuelson was about a 4-year-old boy.
Dan
Pam Delisio. I represent parts of Montgomery and Philadelphia County. It's been my privilege to serve on this committee for the entire time I've been in the House, since 2011, and I come out of the field of long-term care. And I can comment that my colleague Rep. Rowe is one hey of a piano player.
Go ahead.
It's Chuck Miller. I'm Democratic staff for Chair Steve Samuelson.
And Steve Samuelson from Bethlehem, Democratic Chair of the committee. I've been on this committee during my entire time in the legislature.
I'll say I'm Chairman Gary Day. I represent portions of Lehigh and Berks counties.
Welcome to my district. I'm Wendy Thomas. It's the 178th, and I want to say, though, that probably you've just gotten into my district. You all came through Representative Schroeder's district probably to get here. But welcome. I've been on this committee my entire time in legislature, which is a year, a little over a year. And thank you all for coming out.
Hi, everyone. Thanks for coming today. I'm the 29th Legislative District, Megan Schroeder, that covers Buckingham, Warwick, Warminster, and Ivy Land Borough. And I'm really excited to be here to hear about this really important issue. It's come up a lot this year. And I too am a freshman, and this is my first year, but the entire time spent on this committee. So I look forward to hearing testimony today.
And I'm State Representative Frank Ryan, 101st District, which represents my age. and my grandchildren are sitting here to my left. We're very proud of them. I've been in the legislature for 3 years. The last time I was in this area is when we only had 13 stars on the flag. So thanks for letting me be here today.
Do you want to go ahead and tell everybody who you are?
Yeah. All right. So I'll get right into the descriptions of the bill.
Shannon Walker is our executive director for the committee.
Yes. So I've been with Chairman Gary Day since his beginning of chairmanship 2 months ago. So we're getting through this together. Today we're going to talk about 4 bills in front of us: the elder abuse package, House Bill 397, 398, 399, and 400. Representative Mosser, Schlegel Culver, Representative Klunk, and Chairman Day have been working on this elder abuse package for the past 2 sessions. This derived out of an elder abuse case that actually started back in 2011, and there's been kind of a rolling momentum of tweaking this language over the past few years. So the 4 bills themselves: House Bill 397 permits electronic monitoring devices in long-term care nursing facilities. House Bill 398 amends the Older Adult Protective Services Act to create a private right of action for financial crimes against seniors, and it creates a trust fund to help seniors who have been scammed or financially exploited. House Bill 399 by Representative Schlegel Culver. This provides concurrent jurisdiction for the Attorney General's office and the district attorneys to investigate these crimes. And House Bill 400, sponsored by Representative Klunk, amends Title 18 of the Crimes Code to expand the criteria of abuse for a care-dependent person to include posting on social media any types of derogatory photos of an older adult.
So one of the things that we are trying to set out is I'm trying to work with our the Democratic chair, the minority chair, on laying out what this committee is going to work through. We had a great meeting where we talked about a lot of issues that are important to him and his caucus and also our caucus. And this package is something that I had a bill in the package, so I was wondering where it is, and I thought it was important. That's why I had a bill in the package. My particular bill amends and establishes, a right of private action for people that are in this situation of financial abuse. And it's something that I just met with former Judge Emil Giordano yesterday, and he just really laid out and underlined and said to me, it's really, really important. There's a lot going on. There's a lot of things that he saw as a judge, testimony that he heard. He was a statewide candidate, went all over the state, and he just really reassured me that this is a great thing for us to be working on. Most of our stakeholders here, know that already, so the people in the front row here know that for sure. And I'm glad that you guys are here, because the purpose of a hearing, which our minority chair has told me a lot of times, that it's important to have a hearing to bring in information about these bills and vet them and learn more about the people who are out there trying to fight some of these problems that we're talking about so that we get this right with the legislation that we have. Now, before we go to the stakeholder panel, Chairman, is there anything that you'd like to add or talk about before we go to the panel?
No, I thank Gary Day, our chair, for scheduling this hearing. It is very important. Some of our other committees don't seem to have a lot of hearings, but I appreciate that the Aging and Older Adult Services Committee has a long record of making sure that we discuss and analyze all of the issues. We've had a lot of dramatic testimony over the years about elder abuse in Pennsylvania and financial elder abuse, and I look forward to this discussion today about these legislative proposals. Thank you, Representative Day.
Thank you, Chairman. I appreciate your comments and look forward to working with you and leadership in this committee so that we can address these issues. Now we're going to hear from some of our stakeholder panel. We have extended the invitation to testify at today's hearing to AARP and the Attorney General's office as well. Unfortunately, they were unable to join us, but the Attorney General's office has submitted comments, and we anticipate AARP will be submitting remarks for the record as well that'll help us in deliberating and coming to the proper, legislative solutions that we vote on in this committee. With us today, we have Denise Getgen, Director, oh man, I should let everybody introduce themselves, right? Make sure I get this right. But Director of Protective Services for the Pennsylvania Department of Aging. We have J.R. Reed, Executive Director and Chair of the P4A's Protective Services and Guardianship Committee. We're going to be working on a lot of different things with guardianship later in the year, I'm sure. Greg Rowe, Director of Legislation and Policy for the PA District Attorneys Association. Thanks, Greg, for being here. And joining Mr. Rowe are two Deputy District Attorneys for Bucks County, Kate Kohler and A.J. Garabedian. Hold on, I'm going to try it. Garabedian? Garabedian, okay, there. Also today, that's panel one, right? Yep. So, okay. So, with no further ado, I'd like to start. The panel can pretty much decide. I think you guys know each other, and we're probably talking to each other about how you'd like to proceed. So, floor is yours.
Good morning. The Pennsylvania Department of Aging would like to thank Chairman Day, Minority Chairman Samuelson, members of the committee, and staff for the opportunity to provide testimony regarding a package of legislation aimed at addressing the growing issue of elder abuse. Representative Mosser's bill, House Bill 397, Chairman Day's House Bill 398, Representative Culver's House Bill 399, and Representative Klunk's House Bill 400. Representative Mosser's House Bill 397 amends the Healthcare Facilities Act to allow residents or a representative of a resident to place electronic monitoring devices in a room with appropriate notices and consent of the facility and other residents. A monitoring device is defined in this legislation as a video surveillance instrument installed in the common areas or a residence room of a facility under the provisions of this chapter that broadcasts, photographs, or records activity occurring in the facility. Several conditions need to be met prior to the installation of a monitoring device. The department has several concerns of privacy and consent with House Bill 397. The bill requires the consent of the older adult or a representative of the older adult, which has the possibility of taking away an older adult's right to deny the viewing of any video. This legislation does not include a provision providing for an individual who lacks capacity to properly provide consent. It is also not clear on consent issues surrounding recording instances of abuse versus recording private conversations. The department would like to work with the bill sponsor and committee to address our concerns if House Bill 397 plans to be considered at a future House Aging and Older Adult Services Committee meeting. Chairman Day's House Bill 398 amends the Older Adults Protective Services Act to add a definition of financial exploitation and establish a right of private action, a private right of action for certain financial crimes. Additionally, this legislation adds a $100 fee for those proceedings to create an older adult financial exploitation trust at the Department of Treasury. Updating OPSA, the Older Adults Protective Service Act, is a legislative priority for the department, including adding the definition of financial exploitation. Years of work and input from legislators, stakeholders, and the department have gone into updating OPSA. We recommend the terms financial institution and financial exploitation mirror the definitions provided in either Representative Hennessy's House Bill 1930 or Senator Mensch's Senate Bill 819. If financial exploitation is added to OPSA, training and reporting guidelines for financial institutions should be included, which are also provided in House Bill 1930 or Senate Bill 819. If the legislature is interested in amending OPSA, it should also be an opportunity to update terminology and address outdated practices. The department is not opposed to House Bill 398 creating an older adult exploitation trust fund, but it is unclear how the fund would assist victims of financial exploitation. We look forward to working with Chairman Day and the committee on receiving more clarification on the older adult exploitation trust fund. Representative Culver's House Bill 399 amends Title 19 to create the offense of financial exploitation of elderly or care-dependent persons and provides for concurrent jurisdiction to the Attorney General. The department is supportive of this legislation as assessing penalties on criminal actions against older adults will create accountability and elevate the seriousness of such crimes. Again, we recommend the definition of financial exploitation mirror the definition included in House Bill 1930 or Senate Bill 819. Additionally, the term elderly should be replaced with older adult throughout the bill. Representative Klunk's House Bill 400 amends Section 2713.1 in Title 18 to include a misdemeanor offense for abuse of a care-dependent individual via social media. The department supports this legislation, but requests that the legislation be amended to encapsulate all forms of media, including broadcast, print, social, or digital. Considering how much technology has evolved since the initial inclusion of abuse of a care-dependent person as a criminal offense, the department supports the initiative to update this definition to include all forms of media, especially social. The department appreciates the interest of this committee and legislatures in addressing elder abuse as a growing epidemic. We look forward to working with the General Assembly on protecting and better protecting Pennsylvania's older adults. Thank you.
We're going to take the entire panel before we take questions.
Okay, thank you. I want to thank Chairman Day and Chairman Samuelson for inviting me and the rest of the panel, or the rest of the committee today for having us. My name's J.R. Reed. I'm the Executive Director of Lehigh County Office of Aging and Adult Services. I also serve as the Chair for Pennsylvania Association of Area Agencies on Aging for the Protective Service and Guardianship Committee. Thank you for this opportunity to come today and provide comments and answer questions about elder abuse and pending legislation. The Older Adult Protective Service Act was implemented in 1988. All the area agencies on aging have had the responsibility to receive reports and investigate potential acts of abuse, neglect, financial exploitation, and abandonment of individuals 60 and older since its inception. So the intent of the act has always been a last resort when providing services to older adults in the Commonwealth. It has been the role of the area agencies on aging to take reports, conduct investigations, and provide services to older adults in the least restrictive means. The older adults' right to self-determination and maintaining their dignity is a core value when providing these protective services. So with respect to House Bill 397, allowing families to have electronic monitoring in long-term care facilities, this is a concept that is utilized by the long-term care ombudsman, is one that is of having a highly visible presence in facilities. So this is another program that is operated by the AAAs. It is important that families make sure that a visit and advocate for loved ones occurs when doing so. So when people live in long-term care, it's really important that they visit, they show up, they have a presence there. Our ombudsman programs do that. I really believe this language in this bill would maybe have another means to be able to possibly do that. I do agree, though, with the department in that a little bit of the concerns I had when I looked at the language had to do with when somebody's incapacitated, who allowed them to represent on behalf of them. It wasn't very clear to me. Should it be a power of attorney? Should it be somebody that's the guardian? I think there needs to be some clarity on that because there could be some problems in administrating this bill if there wasn't very clear language when the older adult can't make those kind of decisions. Over the past several decades, things have changed in respect to financial exploitation towards older adults. With online transactions and much more accessibility to individuals' assets has brought an enormous increase in the amount of funds that are being taken through scams, power of attorneys, and other deceitful ways. In looking into the impact that financial exploitation has had on our society, national studies estimate anywhere from $2.9 billion on the low end to $36.5 billion on the high end is exploited from older adults every year. A 2016 study conducted by New York Office of Children and Family Studies said that the study concluded that between $352 million to $1.5 billion was exploited in each New York State district. So with those statistics, I don't know that we even understand fully how much impact happens on older adults that are being scammed across the entire Commonwealth and the United States at this point in time. It is vital that legislation be updated to assist with protecting, recovering, and prosecuting individuals that commit these types of acts. We need to have the tools and the resources to combat financial exploitation. House Bill 398 adds a chapter to OPSA and gives immunity to financial institutions or advisors who are reporting financial exploitation. This will encourage more reporting of exploitation, which will result in protecting more older adults. I would also suggest wording that would require these reporters to provide records quickly as possible. This will expedite investigations. It will provide timely protection of older adults' resources. The addition of civil remedies to recover funds for the older adult of their family and their family is important. Another roadblock is when the older adult no longer has any assets or funds to be represented civilly before the Commonwealth courts to gain restitution. I am hopeful that the Older Adult Financial Exploitation Trust Fund will assist some with this roadblock. The details to the trust fund will be vital in who it serves and how it is administered. I would suggest that maybe a scaled fee be applied according to the amount of assets that are taken, similar to House Bill 399, where it scales on what the felony accounts are for how much money is exploited from the older adult. And I would suggest starting at the low end with $100 and going up from there, $100, maybe $500, and maybe $1,000 for the next, just because of the amount of money that's taken from older adults. House Bill 399 provides concurrent jurisdiction to the Attorney General to assist with financial exploitation cases. This will assist with resources to investigate these types of crimes. Two difficult challenges with processing these cases are the cost to local law enforcement for forensic accounting and the older adult having a cognitive impairment preventing them from being a good witness in those cases. So adding the Attorney General as an option may assist local entities with combining resources. They may be able to leverage those resources and get that accounting, forensic accounting done for the older adult, because oftentimes there's just not enough money. They cost thousands of dollars sometimes to do the forensic accounting that's necessary. So I support the idea of stricter criminal charge classification for these types of crimes. Also, I've seen in my career where individuals, oftentimes we can recognize that there's hundreds of thousands of dollars that are taken, but the local law enforcement can maybe get, like, I remember one case where it was $18,000 and there was well over $100,000 taken from that individual. So I really think that sometimes what happens is people fly under the radar. It's very difficult for the older adult to testify. It's difficult for the DA's offices to prosecute these, and as much as we can administer making sure that people are held accountable for the kinds of crimes that are being committed is very, very important. House Bill 400 addresses unauthorized derogatory postings on social media by staff of facilities against neglect of care-dependent individuals. I strongly support making this type of crime a misdemeanor. One of the core values of the AAA network is the dignity of the older adult. This is a part of the Older Americans Act. This behavior by staff goes against our core values by publicly stripping older adults who cannot defend themselves of their dignity. We had a recent case in Lehigh County where an individual posted a video showing demeaning behaviors towards residents at a personal care home. This individual was charged with crimes that were less than misdemeanors for these actions. In my opinion, someone that demeans older adults in this way shouldn't be allowed to work in this industry. This bill will aid with the prevention of these types of crimes because the criminal background checks currently in OPSA help to identify perpetrators of certain types of crimes and ensure they won't be able to work in long-term care settings any longer. There have been dramatic increases in the number of reports of elder abuse and investigations over the past several years. This is due to the overwhelming number of Pennsylvanians reaching 60 and having longer lifespans. One of the fastest growing populations are those 85 and older. And statistically, 50% of that population has some type of dementia. I was watching a local news station in the Lehigh Valley where I live, and one of the stories reported recently, maybe a week or two ago, is that every 3 seconds across worldwide, somebody's diagnosed with dementia. Pennsylvania Department of Aging annual report on protective services for fiscal year 17-18 shows over 12% growth in elder abuse reports received by AAAs. The previous fiscal year on the same annual report showed a 17% growth of elder abuse reports. In Lehigh County, we had a 20% growth from calendar year 2018 to 2019 and received reports of elder abuse. These increases can primarily be attributed to the population increase occurring with those 60 and older in the Commonwealth. It also points out the necessity to have funding to address these growing population's needs, especially to the most vulnerable of them that have served through protective services by other systems and that are abused and neglected and exploited. I want to thank you for taking on the challenge of updating legislation, addressing some of the issues with older adults. I support all these smaller pieces of legislation. I also want to encourage that full OPSA legislation continues to need to be updated. These pieces are a start, but they don't address the comprehensive changes included in the full legislation. So much work has been done over the past several years, and it needs to be completed. Passage on these smaller pieces of legislation cannot delay the passage of comprehensive OPSA changes identified in House Bill 1930 or in Senate Bill 819. These will benefit many older adults that live in the Commonwealth. Again, I want to thank everybody for allowing me to come here and allowing us to testify on behalf of the AAAs.
Thank you. I will have comments about that, but you guys want to go? Greg, do you want to go?
Great. And good morning, and thank
Thanks.
you. Again, I'm Greg Rowe, the Legislative Director and Policy Director for the District Attorneys Association. I've got Kate and AJ on either side of me who are from the Bucks County DA's office and handle elder abuse cases, both financial and physical abuse that occurs. And we really want to sort of do two things. Number one, in a minute, I'm going to turn it over to Kate and AJ, who are going to talk about some cases that they've handled and the perspective that they see. And from those examples, provide some policy recommendations, some of which go a little bit beyond the bills that are here, but hopefully that may provide a roadmap for this committee and perhaps the Judiciary Committee together of some ways of preventing further abuse of older adults. And then number two, I'll close it out for us by offering some comments on a couple of the bills that we support. And these are all great bills, by the way, but a couple where we want to offer some refinements to further amplify their potential to have a great impact. I just want to make an overall comment to thank all of you for this hearing and for these bills. This is clearly the logical next step in terms of what the House and Senate, particularly the House, has done as of late with regard to public safety. And there's been a bipartisan emphasis on dealing with legislation that helps the most vulnerable victims. And we saw it this past, earlier this year with the human trafficking legislation. If there was a negative vote on any of them, I'd be surprised. And they passed with just wonderful bipartisan support, and Representatives Thomas and Schroeder are here. They had bills in that package. It was great. Now it's in the Senate for hopefully they'll deal with. Last year, we had bills that passed virtually unanimously that helped the most vulnerable victims, particularly kids, those who are victims of sexual abuse, and those who suffer from intellectual disabilities, to better allow them to testify in court and confront their accusers. So this is really the next logical step, and we're if I didn't say how much we appreciated this hearing and this emphasis, I would be totally remiss, because it is important. And again, we're greatly appreciative. I'm going to turn it over to Kate and then AJ, who are going to talk about some of their cases, and then we'll comment on a couple of the bills.
Thank you, Greg. Good morning, everyone. Thank you again for having us here. My name is Mary Kate Kohler, and I am a district attorney for Bucks County. I've been a district attorney for 7 years. I'm a part of the Special Victims Unit, and AJ and I are literally the Elder Abuse Task Force in Bucks County. He handles the financial exploitation, and I handle the physical and sexual abuse as well as the neglect cases. Obviously, well, unfortunately, physical and sexual abuse are prevalent in this country and still in this county, and it's unacceptable. Our most vulnerable population is the elderly population, because they are most at risk, and they're easy prey for abusers. Most of the abuse occurs at the hands of most of the abuse against the elderly occurs by people who that person knows, usually a caretaker, and in particular in the nursing home settings, those people who work in the nursing home or volunteer around them. There are 70% of reported abuse that occurs in nursing homes, and only 30% of victims of elder sexual abuse are reported to authorities. Elderly women are 6 times more likely than men to be sexually abused, although we do know that men are abused as well. Given the fact that most of the abuse occurs at the hands of a caretaker, one of the most logical and common sense ways to prevent it, or at least attempt to deter it, is to ramp up the monitoring efforts, which I believe House Bill 397 attempts to do. And I am in support of that bill. I do believe that it's one significant way of minimizing the risk of abuse is increasing the monitoring efforts, and will also allow prosecutors, such as myself, to more easily hold people accountable when it is, it's very good evidence when it's on video, obviously. That's the dream. It never happens that way. But just having a camera in the room, I think, is a huge deterrent, because it takes away the opportunity that a lot of people so often have, because a lot of times they're one-on-one with these patients, and a lot of the patients are dementia patients, or they have significant mental delays, and they don't recognize it's abuse, or they don't remember to report it. So it's happening all of the time. And I know most of these bills are not directed against physical and sexual abuse, but I did want to take the opportunity here today to highlight 2 cases that I've had to deal with that highlights 2 additional loopholes, I guess, in the law that should be closed. One of them is the Commonwealth versus Scheimer. Both cases are particularly gruesome, unfortunately, but here, the victim was a 96-year-old physically disabled woman with dementia. She was living in her daughter's home with her son-in-law as well, and essentially depended on them for everything: her food, her transportation, her medication, everything. And one day, the victim's daughter walked in on her husband standing over her mother with his pants down and his penis out, and telling her to perform oral sex on him. He fled the house when his wife walked in on that occurring, and subsequently she recorded a conversation with him on the phone where he essentially confessed to having actually put his penis in her mouth on numerous occasions, multiple times, and he claimed that he regretted what he had done. Obviously, we were investigating that, and we were the ones who recorded that conversation and charged him with involuntary deviant sexual intercourse. At trial, he sought to prevent the introduction of that recorded conversation in trial, and because of the applicable spousal privilege that's on the books. And as a matter of law, he was correct. We were not allowed to introduce that crucial piece of evidence that actually was the only evidence that we had that there was penetration in this case. So we believe that consideration should be given to providing narrow exceptions to the spousal privilege in cases where the victim is elderly, care dependent, or otherwise vulnerable, and the underlying crime involves physical, sexual, or even financial abuse, but definitely physical or sexual abuse. And that is one situation that occurred in the home, and again at the hands of a caretaker, which happened to be a family member. Another case that occurred in a nursing home, Commonwealth versus Frederici, and here the victim was actually 93. I think I made a typo, sorry. She was a 93-year-old resident at the nursing home who, again, relied on her caretakers for her basic needs. Her daughter would come visit her from time to time, was very involved and active in her mother's care and life. However, her mother was in and out of a state of lucidness. She suffered from dementia. Some days she was with it, some days she was not. One day, another worker at the nursing home walked in on a caretaker standing over this woman who was laying on her bed, and his penis was in her mouth, and her diaper was off. That worker, thankfully, did report that abuse and did actually view what had occurred. However, the defense in this case was that the resident consented to the oral sex. Now, we could not, given the fact that this woman was in and out of a state of lucidness, we could not, as a matter of law, say that she could never consent. So consent was the defense, and it was a valid legal defense, no matter how ridiculous that sounds. So it was a great impediment to this case, and it was very troubling that that was something that the defendant was able to rely on. However, we believe, based on that circumstance, that consideration should be given to expanding the crime of institutional sexual assault to include in-home care workers and nursing home facility employees and volunteers. Such a change would eliminate consent as a defense in these cases, which is extremely important. Presently, as many of you may know, institutional sexual assault applies in settings such as prisons and schools, where those in a position of power, such as prison guards and teachers, are not permitted to have sex with prisoners or students, respectively, because when someone is in a position of power over you, true consent can never really occur. I believe that that's a very similar situation for nursing home facilities. Nursing workers, employees, what have you, anybody who is in the nursing home should not be having sexual relations with any of the residents for any reason whatsoever, and expanding this statute that's already on the books would significantly help us in prosecuting these particular cases and taking away consent as a defense, because it's absurd. And that is what I would like to say today. So I'm going to give AJ the floor.
So again, I'm AJ Garabedian, and I'm with the Bucks County District Attorney's Office. I handle a lot of the, most of the financial exploitation of the elderly. Generally, what we are seeing are thefts committed by powers of attorney. I mean, they're not solely the ones that are committing the thefts, but generally they seem to be the most prevalent types of cases. And the problem that we face, there's multiple problems that we face in these prosecutions, but ultimately the problem is that if we are to prosecute, if we're to convict somebody, by the time the cases come to our office, the money's gone, and there's very little chance of us getting it back. So one of the things that I saw in the bills and that I encourage is that I think it gave financial advisors civil and criminal immunity from reporting these types of crimes to law enforcement, and I think that's a great thing if we could encourage banks or financial advisors or accountants to come forward when they see something and to let us know. We can get in there and we can stop it before these individuals commit further thefts. So I think that is a great idea. Also in these prosecutions, the victims are suffering some sort of dementia. That's usually why they're taken advantage of. And I think the power of attorney individuals know that, and that's why they do it. So in one of the other bills, I think there was a provision that the power of attorney is presumed to understand their duties under, I think, Title 20. I think that is a great idea, and that certainly will help us in prosecuting cases where we might be on the fence about whether we're able to prove this or not. I think that will give us the ability to go forward with some cases where right now, we're currently not able to do it. So I encourage that as well. And again, the hearsay exception, many times we're not able to have these individuals testify. Bringing them to a preliminary hearing is just something that is not going to happen. We don't want to bring them out of their care facility. So I think expanding the hearsay exception to preliminary hearings so we don't have to bring these individuals to come testify, I think that is a great idea. I'm sure many of you have heard the stories of financial abuse throughout your districts. Bucks County is not immune to that. We're talking cases where it's hundreds of thousands of dollars, and it's any type of individuals, certainly family members who become powers of attorneys. We see several occasions the home health care workers that go in and take credit cards and start using them. I recently prosecuted a case where we had an accountant who had financial capacity over 5 individuals, where we're talking close to $500,000 of money. So it's everybody who is committing these crimes. So I just ask you to take that into consideration for this legislation, and because I'll turn it back over to Greg.
So just had a couple quick comments on 2 of the bills. One is House Bill 399, Representative Culver's bill. We support the bill. We think there are some ways to really amplify the theft prosecution provisions in the bill. You've heard from my colleagues here that a lot of these crimes, typically these crimes are committed by those who have some or in some position of trust over the victim, be it a family member, somebody who lives in the household, like a home health care worker, somebody who lives in a nursing facility or some sort of healthcare facility. We would recommend that sort of that cohort of individuals, those in a position of power or trust, be the potential defendants for whom penalties could be increased. We don't need a change to the law to penalize a person who steals a purse from a 61-year-old person. We do need a change in law, by contrast, for a home health care worker or a nursing care worker or a financial analyst or broker who takes advantage of a 61 or 71 or 81-year-old victim. And if we can work on language to sort of refine that, we've cited to the New Jersey statute, which is similar in terms of what I described. It's only about 2 years old. They do a really good job of providing some definitions of who the people in positions of power or trust are. That's what our primary recommendation in terms of what should be included in 399 would be. Number 2, with regard, much more technical point, I think it's 397, House Bill 397. There is a small provision in there making it a crime to tamper with the video, any videos that would be in the room. And that's good. But it incorporates a different crime almost by reference. For us, that would be very difficult to prosecute those crimes because if you've incorporated it by reference, it might be unintentionally unconstitutional because it's vague. So we would just recommend just putting in the elements in the bill so there's no ambiguity in terms of what the elements are. And finally, same vein, ambiguity. There's a good immunity provision in there about somebody who reports a misused video. That's great. We would only say that the immunity would apply to any conduct covered by the bill, by the section, so that if you're using the video for something completely unrelated to the new provisions there, we wouldn't want immunity. We would only want it with regard to tampering with the evidence. So I think to close out, one of our themes here is so much of the abuse that occurs is committed by those who know the victims, and they are so many times targeted because they are especially vulnerable. So to the extent we can work on language that really hones in on those individuals, I think we'll have a huge bang for the buck and get the right people and not be overly inclusive at the same time.
Thank you. Thank you all for your comments. We're going to move to questions from members up here. Members, if you have questions, let either the chairman know or Shannon know that you have some questions. I wanted to start off, and then I'll go to our minority chair. But I wanted to quickly start off with a couple quick questions. First, maybe a comment. You had brought up about OPSA. Yes. We've talked about this, but just for the record, we are working on the overall thing that we've been working with OPSA. We're working with the administration as guidance for this committee. I've talked to many of the stakeholders and our members about trying to do many different bars, almost like project management, 3 different levels. OPSA is number 1 for us. This package of bills is a 1B, that we're going to work simultaneously, both of those through the process. I know the administration has some ideas for at least one piece of legislation, maybe some other ones that we're working on, all in conjunction. And hopefully, we're going to bring those to fruition in what we would call the sprint, the first half of this year, and then work on and study things and bring to votes in the fall, guardianship issues, and the rest of the bills in committee, come up with a plan for all of those members and their bills. So I just wanted to make a quick comment about that. Ma'am, your comments about asymmetrical power relationships and how we should forbid people in that and include that hits very strongly and hits home for me. It's something that I had worked on and researched and realized that when someone's in a position of authority and power over another person, that we can forbid them, and that would take away the ability for anyone to consent in that situation. I recognize that individually. I have to share that with the members and that information, but I appreciate your comments on that. With that, I would appreciate any language, definitions, where that should be in the statute. It probably should be everywhere, a defined term, right? But I wanted to also ask you, the DAs, about the spousal exemption that you're asking for. Could you explain what is the law on spousal exemption, why we have it? Because I think it's important. It's an important foundation that many criminals take advantage of, right? But there's a reason why we have that there, for an expectation of your closest circle, right, to be protected conversations. Explain why we have that protected conversation, and then therefore also explain why you'd be asking us for that exemption.
Yes, of course. You basically hit the nail on the head. The spousal privilege it's meant to foster open communications amongst a marital couple, and it's a great privilege, and it should be. I'm not asking to get rid of it by any means. There are 2 different spousal privileges that exist. One is a testimonial spousal privilege, which at this point essentially means that a husband and wife cannot be compelled to testify against each other unless one or the other one waives that privilege. It's waivable by one spouse at this point. However, there's an exception in the testimonial privilege section that there's this specifically delineated exceptions if there is a domestic violence situation, or if one of the spouses is charged with involuntary deviant sexual intercourse or rape. Those 3 instances, the privilege does not exist in terms of the testimonial privilege, meaning that even if, let's say, a husband and wife get into a domestic dispute and the wife does not want to testify and she tries to invoke the spousal privilege, the privilege does not apply to that anymore. So she has to testify when she is the victim. She cannot, at least, I shouldn't say she has to testify, but she cannot invoke the spousal privilege to prevent her testimony. However, there is a confidential communication spousal privilege. There's 2 separate things. And what that is basically any conversations that you have with your spouse during the course of a marriage is protected. And both spouses have to waive that in order for one of the spouses to testify against the other about words that were said during the course of the marriage. There is no codified exception in that segment of the spousal privilege. However, there is case law that extends child abuse, the child abuse exception in the testimonial privilege side of things, to the confidential communications side. So, but it does not specifically delineate certain crimes that should be an exception where it should be waived, and therefore any communications, and in particular in this case, because the defendant and his wife were having a conversation about what occurred, even though he confessed to her, She was willing to testify and she wanted to, but he prevented her from doing it because he would have to waive that privilege as well because it applied. What we're asking is to carve out an exception for the spousal privilege, both in the testimonial and confidential communications privilege, that would exclude certain crimes from being covered by that privilege. So essentially, the privilege wouldn't apply in certain situations where, for example, involuntary deviant sexual intercourse or rape, or even just sexual abuse in general of an elderly, care-dependent person and a child, is if that's the situation. So as it stands now, essentially children are somewhat protected, and that exclusion has been somewhat, although it could be better, excluded from that privilege. But and they are obviously a very vulnerable subset of society, but I would argue that the elderly are just as, if not even more vulnerable in certain situations because they are never going to be able to come back. Children grow up. They will be able to speak out about certain things. Elderly with dementia, you're never going to, that's not going to happen. So I would argue that they are, if not as vulnerable, even more vulnerable than children. Right now, children are protected, and they should be. I definitely advocate for that. But I do believe that the elderly should be protected as well.
Thank you for your answer. Chairman Samuelson, do you have any questions?
Yeah, just a follow-up to that. The spousal privilege does not apply in cases of significant others. It has to be, or is it, as case law interpreted, that would also include cases of boyfriend, girlfriend, or significant others?
You have to be married. It's communications that occur during the course of a marriage amongst the spouses. So if you're no longer married and you communicate about something, even though you were married, it does not apply. But let's say I confessed a crime to you and you and I are married, and then we get divorced. I still can't testify to what you told me during the course of our marriage. So it doesn't end upon divorce.
And currently we have no exceptions to the spousal privilege?
For the confidential communications side of things, the only exception is for child abuse.
Okay. Not murder, terrorism, mass shooting?
Murder it's murder, rape, and involuntary deviant sexual intercourse for the testimonial privilege and domestic violence. But for confidential communications, I don't believe there is an exception.
Gotcha. So perhaps if we considered this for the situations you're talking about with elder abuse, we may also want to.
Yes.
Yeah.
I'm
thinking of the case of the mass shooter in
expansions.
Orlando, Florida, where 49 people died, and apparently the spouse knew quite a bit, but then was acquitted of all charges.
Right. Right. And I can certainly submit some other ideas to you if you would like. I have a lot of them.
Okay.
And Reb, if I can add, there is a little precedent, slightly different situation, but the wiretap law, which was amended on a bipartisan basis 7, 8, 9 years ago, we created some exceptions to the rule that both parties have to consent in order to record somebody else. The most serious crimes, limited situations. So as we work on this and get you language, that would actually be the first thing that we would use to try to do as much copying and pasting as possible. We had a very similar sort of analysis and discussion years back on that, and had to, again, be very narrow and very precise.
Thank you, Chairman. Do you have more?
I have one question.
Go ahead.
One question. We're talking about forensic accounting and trying to get the evidence when there's a financial abuse. In past hearings, we've talked about how Temple University has a unit that is utilized by district attorneys across the state. Is that still the case? And are they able to be available to? Are they able to meet the demand for their services?
We currently have 2 people at Temple who do help help the area agencies on aging do financial cases. On top of that, we can, on a limited basis, do some purchasing of financial accountant work. Some of the area agencies on aging also have contracts independently with financial accountants, but they're very expensive. So we have, with the money that we just have put out, thank you, been able to purchase someone who's available to help some of the area agencies on aging as well. So we do have some resources, but again, it's very expensive.
And that's a contract with Pennsylvania Department of Aging and Temple University?
Yes.
Okay. Thank you.
Thank you, Chairman. Next, we'll go to Representative Frank Ryan.
First of all, I can't thank you enough for the testimony. It was extremely helpful. And Kate, I would have an entirely different visceral reaction to someone who would do that to a parent of mine and I applaud you for going through what you're going through. I don't know any easy way to ask the question, so I'm going to ask you to give me the benefit of the doubt. If my question doesn't come across properly, please ask me to clarify. As you can tell, I'm in the elderly category, despite the fact that I'm a relatively new legislator. I always worry about people my age and about our reaction to people your age telling me that I've got dementia or other issues of ability. And I worry about the impact on the care providers who are attempting to provide assistance to me while I'm easing my, and by the way, I'm not going through that right now. Although my wife just texted me and she said, yes, you are. And so, but we're dealing with an elderly parent of my wife at this point. And those a willingness to give up those rights. If someone were to tell me, as an example, tomorrow your vision's such you can't drive, I'm probably going to fight that pretty hard. And so my concern is, do we create an unintended consequence? And if so, can we get your guidance to avoid it? Because I'm a co-sponsor on all of these bills, and I wholeheartedly support it. But I want to make sure that we don't inadvertently put seniors in a position where they are denied the care they need because of the litigation risk of something, particularly as it relates to a financial allegation. I am a CPA, and I do extensive fraud and forensic work. That's what my practice is. And my House Bill 985 gives the Auditor General a fraud and forensic capability, and will be designed specifically for this, because the cost of dealing with some of these issues can be prohibitive for your offices to want to get someone to do if it's a $10,000 crime. And so I designed that specifically into it. So the question I would ask for you is, how do we deal with the potential transition issues of someone from full mental cognitive abilities to less so, while at the same time our reimbursement rates for caregivers of seniors has been negatively affected, particularly under Medicaid, and the ability to get people that are not rotating on such a rapid basis. The provider of the care for the senior is finding themselves in a continual training mode where the turnover rates might be as much of 100%, to where people are being inadvertently accused of crimes, particularly in the financial area. Kate, in my mind, there's no inadvertent crime. Anybody who's doing that, and I support 100%. There's no reason somebody in that work should be having type of sexual relations with a senior. But I do worry about this transition issue, and the senior who says, look, I'm in full cognitive ability, and my abilities, don't you tell me what I can and can't do. And what someone's perception of a crime, as an example, if someone were to tell an elderly person, you need to go to a more stepped up facility where greater care, I will tell you, I've seen children say that the facility's doing that merely to get more money from the parent. And that, if that's now declared to be a felony, you're not going to have any care providers in Pennsylvania. So how do we do this to where we don't make being in the field such an occupational hazard?
Could I just, Frank, there was a lot in there, and I'm really interested in what you just asked, and I just want to frame up the difference between, pecuniary interest and, a medical decision for people. Also with the CPA things that he mentioned, that a financial person, if they do their job the way you do it, they'll have everything laid out, and what they've been after, I think in the DA's offices around the Commonwealth, is when it's kind of hidden and you can't get the facts. So I think I hope they're going to talk about how financial people who have all their records will never face prosecution, right? It's the ones that we can't get the records for. But I hate to, but you had great things in there that I want to make sure that they direct
So-
their responses
So
toward as well.
maybe if I start and then they can talk about the prosecution piece of it. So as an area agency on aging, when we receive a report that somebody's being financially exploited and they're 60 and older, what happens is we begin an investigation. That investigation entails going out to see the older adult, primarily, number one. So in that, we have investigators that go and talk to them and try to find out cognitively where are they at. Now, our investigators aren't nurses, doctors, medical professionals to say officially what their capacity is to make those kind of decisions. But part of the investigation also is calling the doctor's office. Now, if the older adult tells us from day one, I don't want you to do this, or this, it does limit our investigations. And, if we're in there and the older adult can talk to us, seems to be cognitively intact and tells us, I don't want you to go to my doctor, or they don't even give us their doctor's name, then we don't proceed from there. Now, if we're in a case and the individual looks like they really are off cognitively, and you can tell those. There's some that you can tell, and there's some that are marginal. They're in between. There's this gray area. Then it just depends on the investigation, how it goes. So we always strive to side on the rights of the older adult. Part of the Older Americans Act that created Area Agencies on Aging and the Department of Aging insists that we do things from a least restrictive means, and we look at the dignity of the older adult. So we always are very careful on how we go about that. And the current OPSA bill really kind of alludes to that pretty much in the regulations and in the law, that we have to conduct our investigations in that way. We might go out, we might find something happened to an individual, and we think that somebody's preying on them, but they don't want to do anything because they're scared that they're going to lose their caregiver and therefore going to have to go into a facility. And if they have the ability to make that decision, we have them sign off on a case, and we suggest to them certain things, and then they tell us no, then we walk away from that circumstance at that point in time.
And Representative, if you make dementia, Alzheimer's, some sort of cognitive disability an affirmative element of the crime, we have to prove it at each and every case beyond a reasonable doubt. That's on us to prove. And you can put a definition in or something, it's on us. If we don't prove it beyond a reasonable doubt, there'll be no conviction. Number two, if you make this an intent crime, in other words, the financial person has to intentionally commit the crime, we have to prove that it was that person's goal and intent to commit this fraud, this financial misdoing. Not reckless, not sloppy, not was asleep at the wheel, that like the stated purpose and goal was to steal money from that individual, whom we also have to prove has a disability. So I think in the terms of the definitions and the burdens and putting it affirmatively as elements of the crime, those will, I think, address the spot-on concerns that you have. And that's some of the stuff we'd like to see incorporated into House Bill 399 a little bit more to provide those definitions and burdens on us.
Thank you. Any follow-up, Frank? Frank, any follow-up?
Just a comment. Thank you very much for that. And I would welcome your guidance on how to tighten that up.
Mm-hmm.
But I don't want to put someone in a position when we're trying to do really good by people to where all of a sudden it's a judgment factor. Because I have firm confidence in what you're doing, but if there's another county somewhere else where someone doesn't have that level of diligence, that someone then says, look, I'm just not going to help the elderly, which is the exact opposite of what we want to see happen. Great questions. Thank you so much.
Thank you. Next, we'd like to go to Representative Pam Delicio.
Thank you, Chairman. A couple of comments, then a couple of questions. And perhaps this is my own sensitivity. So I always am cautious about somebody assuming older adults are vulnerable just because they're older. That is not the case at all, ever. And I hear that, and words matter. So when I hear, repeated use of the word elderly, which connotes feeble, and, not able to look out for oneself, I've known my share of nonagenarians and centenarians that are not vulnerable. But I appreciate the sentiment that is offered here today, but I just want to make sure we're not, we're proceeding with that sensitivity. This 60 and older was set by the feds. There's no magic to that number. I mean, what's the difference between a 41-year-old getting ripped off who may have early onset dementia? Aren't we as responsible looking out for them for vulnerable? So I think we should really work from a definition of what does vulnerable mean and who may fall into that category. We're actually seeing more and more early onset dementia than we have historically. So, you know, if we're just focusing on folks that are 60 and up, it's going to pick up Frank and myself and Steve. This Steve. Yes, it is. So, huh?
I got a year.
Oh, you got a year. So, you know, none of us are vulnerable. So I just put that out there for that orientation and sensitivity. I too would be curious as to the input of folks like the Institute on Protective Services out of Temple to see that does this legislation, in addition to the prosecutors' challenges, which are a set of challenges that are here, does this legislation meet some of the challenges they've seen out there in doing this? And I've heard those challenges being manpower. It happens so far after the fact, good luck. Identifying it, restitution is, a fantasy. All these things are unbelievably unfortunate, but I want to make sure that we have the best legislation to deal with the reality that we're confronted with, not legislation that may not get us to where we actually really, truly want to go in the world that we're living, not in the world we wish were. In terms of some of the power of attorney discussion, I've held that for no less than 3 older adults in my world, so folks north of 80 and 85. And, so if they withdraw, if I go to the bank on their behalf to withdraw $10,000 twice a year because they have grandkids or great nieces and nephews that they want to, Merry Christmas or whatever, if that, and financial advisor, I apologize if I missed the definition for it. It seemed a little broad. So if that person calls your fine office to say, hey, 2 withdrawals have been made, or somebody needs to report to you and go through some sort of bureaucratic hoop to say, I'm sorry, my Aunt Emma had every right to make that withdrawal, and her purpose for doing that is it really your concern? And you want to deal with me, not her. Trust me. So I want to make sure that these types of things don't catch up, as what Rep. Ryan was sort of saying, good folks doing normal family-oriented tasks. None of us like and want to enable the bad actors, ever. But we certainly don't want to discourage the good actors in doing this. One case that was particularly egregious in my 10 years in office involved an attorney who was not acting in good faith, and in fact, just the opposite. And do you know, when I worked with that constituent for months and months and months, and this is still not resolved, nobody would go after the attorney because it was an attorney. Try to get another lawyer to go after a lawyer. And if you all have suggestions, I'll be happy to hear them after this. It was unbelievably challenging. It is yet to be resolved, because it's another lawyer. Nobody's going to take the case. Nobody's going to do this. Nobody's going to do that. So I just want to make sure there are no de facto exemptions, or there's an easier way to also include, very often people are consulting their attorneys and giving them these powers. And, I'm not sure that power of attorney wouldn't be a discouragement from folks, because if they're going to be held liable from A to Z, and they feel like they're going to have to go to law school in order to hold that power of attorney, I agree with Rep. Ryan that folks may just step back and said, you know what, I don't need this aggravation in my life. I don't have to defend myself for trying to do the right thing. So again, as we proceed and kind of sort this out and sort it through, these are some of the things that I hope we keep in mind. And I will also point out, and I think it was at an aging committee meeting, Delaware County's district attorney's office has a unit that goes after specifically older adult use. They started it quite a while ago, 10, 15, almost 20 years ago, and have had some interesting experiences to share. So they may also be a resource. It's very unusual, I think, that to have the particular unit that I understand Delaware County has and has operated, and try to maybe benefit from some of their situations that they've experienced. And then just last but not least, I know where this focuses on particularly the video thing, and I have my whole questions about the video thing. I'm not sure this is at all a good idea. Would you like a video in your bedroom? I don't think there's one person in this room who would volunteer to have a video in what is in essence their bedroom. You can't keep a resident from wandering, even if the roommate agreed to have it in there, from wandering from one side to the other and being caught on this video or recorded on this video. I don't know what situation, was created or whatever to make folks think this video is a good idea. But you think about what you do in the privacy of your home, because if this is where an older adult is living, or any person who's living, on a 24/7 basis, would you want those things recorded? I get the protection piece.
Representative DeLucia.
So, thank you.
May I interrupt you for a moment?
I need to go on. Sorry.
Yeah, no, I appreciate it, and first and foremost, I want to apologize because I didn't kind of lay this out as a new chairman for this hearing of, the way I see this hearing going, I should have probably had a panel 3 and had you sit on it to comment on this. Because of your experience and expertise in the field, you have a lot to offer. However, the format for this hearing is I've tried to be as efficient with everyone's time, our time and their time, and the audience and the public. So the whole purpose that I'm trying to guide toward is be very respectful and understanding that everything you're talking about has a place to be brought through. I would really appreciate if we could ask them maybe their opinions on those things and try to gather that here with an interaction with them. And then save, of course, during committee, we have such a great amount of time. Sometimes I realize that speaking on a bill at the voting meeting, it might feel like it's too late. So I'm always open to take your information, and I'm sure the minority chairman is as well. And we're trying to do that. So if you have a question for them about any of these bills, that would be great.
They're welcome to comment on any of
Okay.
them. Thank you, Chairman.
Thank you all very much. The other thing I want to say is I have about 4 or 5 minutes left, and I have 3 more members that would like to ask questions. What's that? Okay, so we're down to 2. And we'll definitely put you on in the second panel as well. But I want to give those 2 members an opportunity to get their questions out efficiently, and then if you would like to comment on those things. First is Representative Wendy Thomas.
Hi, thank you. I'll try to be quick. Just one good note, since human trafficking was brought up. We had a human trafficking hearing here in this very room a year ago, and we passed those 8. Now, hopefully, we don't take a year to pass some of these bills, but good karma. Anyway, my question's pretty quick and simple. Thank you for your testimony, all of you. I know when I have my senior fair and things, the biggest attended item is the gentleman talking about don't get scammed, and he talks about strangers, what I view as strangers calling you or getting scammed, I'll call it, from a stranger. And so if you had to say people are getting scammed overall, I'm interested in what percentage happens in this kind of caretaker family category versus stranger, because mostly what I hear about is somebody called you on the phone, somebody sent you an email. That's mostly what I hear in my office, and I assume because if it's a family member, they don't want to talk about it, they don't realize it's happening, something like that. Thank you.
Somebody else?
Anybody who wants to answer?
I didn't know if anybody else had any questions. Okay. So, Representative Thomas, to answer your questions, the dating scams, the lottery scams, those sort of scams, unfortunately, they're not getting to our office. They're going to the police, and the police are determining, well, these people are overseas. We're never going to identify who they are. So I can't give you really an accurate number on those type of prosecutions. I know they happen. They're frequent. Generally, the cases that we are prosecuting are coming from the caretaker role. But unfortunately, for the scammers are good, and generally we're not able to locate them, who they are, their identity. So again, the prosecutions are from that caretaker.
Okay, I was just curious because I hear a lot more about that
a good question.
than I do about the family and caretaker ones.
So I would imagine that it happens probably more than that caretaker thefts, but unfortunately, the prosecutions of those crimes are happening less than that.
Yeah.
So.
Thank you. I think that's a good question. Oh, did you have something? Go ahead.
Representative Thomas, I would just say from what we see at the department, mostly we see, unfortunately, in terms of just straight financial exploitation, family members and caregivers, by far.
Thank
rather
you.
than just, outside, somebody you don't know calling you.
Representative McCarter.
Thank you very much, Mr. Chairman, and again, I'll be brief as well. The question that keeps rattling in my mind, though, is because I know that Representative Benninghoff and I have been both working on bills dealing with a state registry of abusers who seem to be repeat elements, who move from county to county that we don't have records on whatsoever because they'll get dismissed from jobs. They're never prosecuted, but they are ones that seem to be more likely to be the people who are going to continue the abuse of others. Can you comment on your experiences with that problem in terms of the present moment and anything related to a registry that we could help you and help other caregivers or people or patients who need caregiving to be able to know that these people have prior existences of abuse?
I can, in terms of a registry, if it's a publicly accessible registry, I get a little bit nervous because the analogous situation is Megan's Law and sex offenders, and I'll just say there are a whole host of cases before our Supreme Court about the validity of Megan's Law and the scope of Megan's Law. So a recommendation I have is we may need to see how those cases come out before we can work meaningfully on any sort of registry, at least a public registry. If it's a private
we understand the problems. That's
Right.
the reason we're working through it. But I'm curious of your experiences with the fact that there are repeat offenders who are out there that seem to be that there's prior cases when you finally do get the chance to prosecute them, and that seems to be the case.
I would say, and I'll turn it over to Kate if you wanted to add in a minute, but more information that's available, particularly if it's based on a conviction, that helps. I mean, this is all about perpetrators who target their victims, who are shrewd and bright and know how to move from area to area. It's not just in this area, but clearly this is the focus. So if we give folks who are hiring people or in the same house as people the information, that no harm can come from that. Only good and prevention and education can ultimately come from that. So I applaud you and Representative Benninghoff's efforts to sort of thread that needle and do that, because if somebody doesn't get caught, they're in this to gain money. If they don't get caught, of course they're going to continue.
Thank you. Representative Rowe. Oh, Representative McCarter, anything further?
No, that's fine. Thank you very much.
Sorry about that. Representative Rowe.
Thank you, Mr. Chairman. Like Representative Thomas, we hear a lot about the exploitations through utility scams or dating scams, those sorts of things. But something I hear a lot of, and I don't know if it's something that anybody else deals with, and even as recently just this week, individuals who are concerned about family or friends who are older adults being exploited through power of attorney holders on their behalf. Is there a way that you have to address those concerns that they might be justified? They might just be, as Representative DeLisio pointed out, maybe it's just routine familial care. Is there a way to address the concerns of those people who are worried about someone without adding a layer of bureaucracy, as Representative DeLisio added?
So currently, if an area agency on aging gets called and there's a power of attorney involved, we'll begin the investigation. We go out to see the older adult. Again, we look at the cognitive ability, because just because you have a power of attorney, it depends what it says, because they're written all different ways, and it depends on the whole context, because if they're still cognitively able, they can decide what they want to do. The power of attorney can't go against what they're saying. So we look into those things, and probably I'd say somewhere in the neighborhood of 65 to 70% of our cases are unsubstantiated. That means there just wasn't enough evidence to indicate a case or substantiate a case, and that does happen quite frequently. So we look into those claims, and then once we get if we think something's substantiated and somebody's abusing the power of attorney, it just depends on how bad it is. It depends on the cognitive status of the older adult, or where we go. Did a crime happen? If a crime happened, then we call the local district attorney's office or local law enforcement to investigate. It just varies on each case. But the area agencies on aging is a good place to start if somebody really suspects some type of financial exploitation with a power of attorney.
And in the issue of what Kate, you had mentioned about if somebody is mentally impaired, they could have the consent issue is at hand. What then is the path forward if you have someone who is perhaps abusing a power of attorney, but it's for a person who potentially has that mental impairment? And does the consent issue come in there as well, where maybe it's impossible to prove one way or the other?
Well, I think there is one of the reasons people have power of attorneys is if they are not mentally there. So I think that would be a little bit difficult, just to blanket say that that person wasn't consenting to certain financial transactions. A lot of times, and AJ, you can correct me if I'm wrong, but circumstantially we can try to piece things together and go from there. But it is difficult, I will say, because if the victim does not have all of the cognitive awareness, it's very difficult, because one of the things we have to prove, and it's not necessarily consent, it's non-permission when it comes to financial crimes. So that person did not give the other person permission to use their bank card or their credit card to go buy a car or go, withdraw $10,000. It's hard to prove that when you have that situation, and I think we're still trying to figure out a way to legislate that, but we have not come up with a good resolution at this point.
Thank you for your question. Oh, go ahead. You have.
I think for us at the department, we try to work around education to adults and older adults and attorneys, so that powers of attorney are being written in a way that the older adult is signing something that they really understand what the powers that they're giving to someone else really are, and what they're not, because I think there's a lot of misunderstanding around power of attorney for not only the older adult, but other professionals as well. So I think it's, we could do a lot around education to help in that way.
Thank you. Thank you for those answers. And finally, we have Representative Megan Schroeder.
Thank you. Changed my mind. Decided. And it's because of the power of attorney. So I worked in a district office as a staffer for many years, and something that we continually see in our office is the switching of power of attorneys. And they come in very frustrated, and a lot of times it's like the family member was the financial power of attorney, and then like the accountant now is the financial power of attorney. And there is some emotional issues because they feel defensive because they're saying that they now want this person to be in charge of their finances. In those instances, if there's a switch, is there anything like now that a family member would be told to call, that they should be alerting the facility that they're in, if they're in a place for home care, about that? Is that something that we should maybe try to look at as legislative push too, that if there is a change, a switch on the power of attorney to tell where they are staying? Because don't they have to get one of those at their office, the administrative office there?
So, yeah, if you switch power of attorneys, which that can be an issue sometimes with financial exploitation, one family member will take the older adult and take them somewhere, get the power of attorney, go to the bank. Then I've seen those kinds of things happen. Yeah, whenever you get a power of attorney signed, you need to have copies of that and present that to wherever, the bank, to the facility that the older adult's at, to the doctor's office, depending on how the power of attorneys. Those things really need to be presented so that they're aware that this person is power of attorney. And it depends on the language and depends on the cognitive status of the older adult and what's said in the power of attorney.
And that's, I think, some of the issue too, the cognitive state. But also, I think there's a lot of times the trust and the grooming issues that come up that we hear about in our office. So that's just something to be mindful as we go forward looking at this too, I think. Thank you.
Thank you so much, members, for your questions, and our panel for their answers and testimony today. I heard a lot of great testimony that I didn't expect, some of the stuff that you guys talked about, but it's all stuff that goes toward things that we should be looking at to get this right. I will be our committee is going to be considering legislation on these topics that before us, also the OPSA bill in particular, and then guardianship for sure. I can tell you, I promise, you know, we're going to do that with the help and work of all this team up here. And we're open to all the other issues that you brought up as well. And I really appreciate your time. Thank you to panel one. As panel one is leaving, panel two is welcome to come to the front testimony area. Members, we do have probably a couple minutes if you need to attend to a message or something like that, maybe 3 or 4 minutes. Yeah. And then I'll open up second one. Give her like 30 more seconds. I'm going to just ask for everyone's attention for the second panel. Our second panel, I'm going to let you introduce yourself because
You did such a nice job for the first panel.
I did. I was so proud of
looking forward
myself. I think it's important that their names are pronounced the way they want them to be pronounced. And also, what's important about the jobs. I mentioned the one testifier's positions and didn't mention that he's from my home county, and I probably should have at that point. So, Zach, would you start us off with introducing yourself, your position, and whatever else you want to do as an introduction? We'll go down the entire panel, and then go ahead.
Sure. Good afternoon, everyone. Thank you for having us. My name is Zach Schamberg. I am the president and CEO of the Pennsylvania Healthcare Association.
Ann Henry, I'm the Senior Vice President and Chief Government Affairs Officer with Leading Age PA. We represent not-for-profit long-term care and senior service providers.
Hi, I'm Margie Zelenak. I'm the Executive Director for the Pennsylvania Assisted Living Association, and we represent personal care homes and assisted livings in the state.
Good morning. I'm Tasha Cooper. I am the president and CEO of Home Care Associates, a worker-owned home care company in Philadelphia, also a member of the Pennsylvania Home Care Association.
Sure. Chairman Day, Chairman Samuelson, members of the House Aging Committee, Shannon, Chuck, thank you for the opportunity to participate in today's hearing. And Representative Thomas, thank you for welcoming us to your district today. It is nice to be back in the land of Wawa, just so you know. My name is Zach Schamberg. I don't work on behalf of Wawa. I am the, again, president and CEO of the Pennsylvania Healthcare Association, better known to most of you as PHCA. I am also the father of a 3-week-old daughter who's home. Thank you. I didn't want applause. I just wanted to say that because if you see me yawning, I promise I am not bored. So let me tell you a little bit about our association, PHCA. We advocate on behalf of more than 81,000 Pennsylvania seniors in nursing homes, assisted living residences, and personal care homes across the entire state. And we also represent the 40,000 caregivers in those facilities who provide compassionate, high-quality care each and every day. But it's important to note that I am speaking to you today not just as an advocate and not just as a representative from the Pennsylvania Healthcare Association, but as a family member of someone who currently resides in a long-term care facility. I think I told the committee this story last year, but about a year ago, my family made the very difficult decision to admit my grandfather into a nursing home. He's now in a dementia unit in an assisted living residence. 5 years ago, we learned that he had dementia, and last year we came to the very hard realization that he could not live at home unsupervised anymore, and we certainly put up a fight against that decision. Now, some members of this committee may have had to make a similar decision at some point, or you're currently struggling with that decision for a loved one. Representative Ryan, you shared a little bit about your story. So elder abuse is not only an important issue for PHCA and for our membership and for thousands of families across the Commonwealth. It is a very important issue for me and my family. And that's why I'm proud to represent the providers who belong to PHCA, because their number one priority is the safety of the residents entrusted to their care. And please know that we have zero tolerance for actions that jeopardize anyone's safety, dignity, or well-being. And the results show just that. Over the past several years, we've seen tremendous improvements in the quality care provided to our residents. Even in just the last 4 years, Pennsylvania has shown improvement in 19 of 23 national quality measures set for this sector. So given those statistics and the improvements in overall care in our state, you might ask yourself, why is combating elder abuse still such a critical issue? And why are we having this conversation? Because unfortunately, even with every precaution our providers take today, healthcare and long-term care is a human business. And unfortunately, mistakes may happen. Last year, the United States Senate chose to focus on elder abuse in a series of hearings as well. And from those hearings came many new proposals and safeguards. For instance, the Special Focus Facility List was amplified and now reports out to consumers on a monthly basis, warning families about facilities on the CMS watch list in every state. The Do Not Proceed icon on the Nursing Home Compare website was born, in which a single isolated instance of abuse will spur the introduction of a glaring red icon next to a nursing home on that website. And countless pieces of legislation obviously were introduced after those hearings. Now, our national organization, the American Healthcare Association, was asked to participate in those hearings. And I'm going to say now what they said then. Abuse and neglect have no place in the nursing home setting or in any healthcare setting. And even one report of abuse or neglect, though not a sign of systemic failure, is one too many. And that's why we at PHCA and the other stakeholders with me today have made it a priority to work closely with the chairman, with this committee, with the Wolf administration to ensure that those protections are in place. So whether it's this series of bills or whether it's the Older Adult Protective Services Act, we are proud to help lead this fight. And our providers are proud to lead this fight as well. Even in the face of many external challenges, PHCA members are going above and beyond to prevent these instances of abuse. In addition to the countless federal and state regulatory requirements already in place, we have members here in Bucks County even, such as the Wilmac Corporation in Langhorne, Representative Farry's district. They have developed policies and procedures which establish a number of checks and balances that will further safeguard residents to the best of their ability. And we can point to members, I'm sure, in each of your districts across the state who have instituted similar protections. However, again, this is a human business and mistakes will inevitably happen. So legislative packages like this are another avenue to preventing abuse. And for the most part, PHCA supports the legislation being presented today. However, we do have concerns regarding unintended consequences and additional undue burdens and unfunded mandates that will inevitably be placed on providers. For instance, Representative Mosser's House Bill 397. Currently, our members already have individual policies in place to address the use of video monitoring devices in resident care areas, and they work directly and diligently with families on a case-by-case basis to protect dignity and privacy. So again, we're happy to work with the committee as well as Representative Mosser and the other sponsors over the next few weeks and months to make sure that this legislation works for residents, providers, and staff, and we stand united with you in the fight against elder abuse. But I would be remiss if I didn't say this. If we want to truly combat issues in long-term care and assure that providers are able to attract the best staff and the most dedicated individuals and root out as best we can every instance of elder abuse, we must address the harsh realities facing this sector over the next few years, and I am begging this committee to do just that. I mentioned external challenges earlier. Inadequate Medicaid reimbursement, a legal climate that leads to millions of Medicaid dollars pouring out of this state each and every day, a regulatory climate that rivals that of nuclear power and the TSA, and a workforce crisis that I guarantee keeps every stakeholder sitting next to me and every provider across the state up every night, all night. The Perfect Storm is not a George Clooney movie about a fishing boat. The perfect storm is what is happening to long-term care right now here in Pennsylvania. And in the third oldest state in terms of population in the entire country, that storm stands to threaten the care for tens of thousands of residents in the years to come. Because we are roughly 3 to 5 years away from the silver tsunami, in which the baby boomers will age into the demographic most in need of long-term services and supports. Our fastest growing demographic right now today is 85 years of age and older. And here in Pennsylvania, providers are for the first time operating at margins that have fallen below 0%. In fact, the average operating margin for one of Pennsylvania's providers today is negative 2.8%. Our members take very seriously the trust placed in them to care for our loved ones. They take every step possible to ensure their well-being. So let's ensure that we return that favor to them. Again, I am very grateful for the opportunity to share this testimony, and we at PHCA stand ready to work with you on any and all long-term care issues before this committee and the legislature. Thank you.
Good afternoon, Chairman Day, Chairman Samuelson, members of the House Aging and Older Adult Services Committee. Thank you for the work that you do to protect our seniors in Pennsylvania and the opportunity for me to share the great work our Leading Age PA members do every day to ensure the health, safety, and well-being of their residents. As Zach, I am the family member of a person that lives in a nursing home. My mother lives in a nursing home and has for the last approximately 4 years. So some of my testimony brings about my thoughts about being a family member, but also being in this business for 30 plus years now, and some of the experiences that I have lived through. Leading HPA is a trade association representing over 350 not-for-profit providers of senior housing, healthcare, and community services across the Commonwealth. Our members serve more than 75,000 older Pennsylvanians and employ over 50,000 dedicated caregivers on a daily basis. Our members offer a full array of long-term care and senior services. First, let me say that Leading HPA is supportive of House Bill 400, Printers Number 1698, that would amend Title 18 to include postings to social media with the intent to ridicule or demean a care-dependent person. We believe that this behavior is reprehensible and fully believe it should be punishable by law. We're also supportive of including laws that would safeguard care-dependent individuals from financial exploitation, but we may want to discuss some of the details in the language. That said, when we talk about financial exploitations in the nursing facility settings, it's often because assets are transferred during the 5-year look back for medical assistance. And you can see detail in my testimony about that, but what's happening is nursing facilities oftentimes are on the hook for tens of thousands or sometimes hundreds of thousands of dollars of free care because of inappropriate transfers of assets. The other thing that often happens in the nursing facility setting is once the resident is on medical assistance, they must turn over at least a portion of whatever monthly income they have from Social Security checks, pension checks, interest on some bank accounts and those kinds of things. Oftentimes family members will keep those amounts for themselves. And frankly, when those things happen, a nursing facility has little to no recourse to be able to come either against the resident or their family to collect those funds. So as Zach was talking about medical assistance funding, he is absolutely right. We have reached a crisis in Pennsylvania on medical assistance nursing home funding. The reimbursement has failed to keep pace with the cost of care. We actually had a study conducted last year by the accounting firm of RKL LLP, and it shows the gap between cost to provide care and Medicaid reimbursement to be over $631 million a year for nursing facilities. We can't keep it up. It really is the perfect storm. So if we're truly concerned about elder abuse, we must take steps to adequately fund our long-term care safety net to ensure that people in need of nursing home services will be able to find a quality provider. So now I really want to turn to House Bill 397. And, you know, I really appreciate J.R. Reed's comments about families need to be involved if their loved ones are in need of nursing home care. He is absolutely right. So for a lot of reasons, Leading HPA and me personally have grave concerns about House Bill 397. But our first concern relates to the significant workforce crisis that seems to be unending. As I said, I've been working in the industry for about 30 plus years now. We have seen in the past workforce shortages, but they're short-lived. This one is going on for years now, and there is absolutely no end in sight. Quality nursing homes can't find staff today. And even though they're providing good wages, good benefit packages, sign-on bonuses, anything else they can think of or afford to do, they have a lot of vacant positions. And we're fearful that House Bill 397 would only serve to make our staffing shortages worse. Good caring staff are already scrutinized by the Department of Health every time a survey is underway, and sometimes we find those staff leaving because of the scrutiny and basically the atmosphere that surrounds those surveys. Having staff on camera where the care they are providing might be misinterpreted may be the final straw for them to find work outside of long-term care. Leading HPA members work very hard to have a culture of trust and mutual support between staff and residents. Electronic monitoring devices would serve to deteriorate this sense of community. Our second concern with House Bill 397 is the intent of the residents' representative for the use of the electronic monitoring. Unfortunately, not all representatives act in the best interest of the resident. When I worked in a building, we actually had a resident who was placed there because her son was sexually abusing her at home. Would we want to actually give him the ability to then ask for an electronic monitoring to see his mom's needs being cared for? We think this is something that needs to be addressed if we're to go forward with this bill. We also need to spend some time thinking about the roommate. Frankly, Sunday when I was in visiting my mother, I looked at her room and I looked at her roommate's space and I looked at her space and I thought, well, I guess if you hang a camera from the ceiling, perhaps only the roommate would be on camera and not my mother or myself or my family as we're visiting my mother. So I think we need to really think about the roommate if we are intending to go forward with this bill and the protections for those roommates and those visitors. And finally, and Representative Delicio, I'm right there with you. I mean, we really need to consider the individual prior to that nursing home stay, especially if they can't communicate their own wishes. Would they have wanted to be on camera as they're receiving their bath in the morning, or as they're getting ready for bed at night, or if they have an episode of incontinence and they need that caregiver to attend to their needs? I think these things should be considered before we grant such rights to a representative of the resident, and I would look to that definition of representative because it doesn't seem to be inclusive of only legal representatives, but could be much broader, which is also very concerning. For the reasons outlined, Leading HPA opposes patient care monitoring as outlined in House Bill 397, as it doesn't offer protections for unintended consequences. I thank you for the opportunity to provide these comments today.
Hi, good morning or good afternoon, Mr. Chairman and members of the committee. I'm going to take a different approach on my presentation as this is an informational meeting. So we're on the topic of elder abuse. What really is elder abuse? You know, we have no definition for elder abuse in our regulatory departments. Surprisingly, they can be all different from agency to agency. They could be different in the statute. The lack of consistency causes confusion and can ultimately lead to the detriment of Pennsylvania's older adults. According to the Centers for Disease Control and Prevention, elder abuse is an intentional act or failure to act by a caregiver or another person in a relationship involving an expectation of trust that causes or creates a risk of harm to an older adult. An older adult is defined as someone age 60 and older. Now, I'm not as old as Frank Ryan, but I'm a Medicare carrying card member. And I don't consider myself to be an elder. I also have a power of attorney, but I'm still competent. So some forms of elder abuse from CDC are the physical abuse, sexual abuse. I'm not going to read through all of this. I just wanted to give it to you to have some information. Because the CDC recommends the importance of consistent definitions that is needed to monitor abuse and trends. Yet there is an inconsistency of the definition of abuse in our regulatory environment, and there is no specific definition of elder abuse. This is clear when we take a look at some of the current definitions in several departments in the Commonwealth. So on the next page, I show you personal care and assisted living. These are their definitions for abuse, very similar. But you'll notice the last one says abandonment or desertion by the personal care home or staff. That's considered abuse. Now, the next page, we're going to nursing homes. Look at their total different definition. And they have a definition for involuntary seclusion. So we're not being consistent as what's being defined as abuse in personal care and assisted living with what's in nursing homes. And then we go to the next page, and the protective services has a different definition, and so does the older adult protective services. The only two that are exactly the same are protective services and the Older Adult Protective Services Act. So we need to be more consistent on what the definition of abuse is, and even do we need a definition of elder abuse? Because we don't have that right now. In the back of my presentation, I did give you a whole printout from the CDC, from different associations on what their definition for elder abuse is. The other thing in the back of my presentation is the mandatory reporting form for abuse. Let's just take a quick look at that. In OPSA, abuse is reported if you're over 60. If you're under 60, abuse, neglect, exploitation, and abandonment is reportable. So we're not even consistent in our form that we're giving to consumers, providers, whoever's reporting abuse. So I think one of the first things we need to do to actually get a hold of what is elder abuse is to let's be consistent on what we're calling it in the state. So many of the definitions are similar, intent, but not consistent. You know, I started my presentation with this definition to show that abuse can be interpreted differently by regulatory environments and also by individuals, which can lead to confusion for consumers and mandatory reporting. Abuse in the form of financial exploitation has grown over the years. We don't have a definition of financial exploitation, so I'm glad we're looking at that. Seniors have been scammed of their hard-earned money by characters who take advantage of their compassionate demeanor to assist those in need. I'm a former administrator for a personal care and assisted living. That's my background. And as a former administrator, the financial abuse I saw was from family members. Personal care and assisted living in the state is private pay. So it's very important that people have these financial resources to be able to pay for them to continue to live and be cared for in their communities. I'm just going to give you one little example, and this was in the early 2000s. Lovely lady, she was never married, worked all her life at Westinghouse, had finances, but she couldn't take care of her money anymore. So she turned it over to her nephew, who refused to pay her bill for 6 months. And so I called Protective Services and said, I want to file an abuse complaint. And they told me, just go to the magistrate to try and get your money. And I said, no, this man is taking her money and you need to take this report. We did go to the magistrate and filed charges against him. And guess what? They were going to sell all his property. He had bought a boat with her money. And finally, he came up with the money to pay the bill. But you know what? Nobody ever filed charges against him. He moved her out of the community and took her somewhere else. The area agency, Aging, did take over as a rep payee, but no charges, so there's nothing there for him. The other thing we would hear all the time is, oh, my nephew needs this money. He really needs it more than I do. I'm going to give it to him. And then nephew never comes to visit again. Or my daughter has problems. I'm giving her the $10,000 so she can get rid of her problems. She'll take care of me. She'll come see me. But they never do. So I think our issue is more, as we've heard before from the other panels, it is family members that are abusing residents more financially. And we need to put that in check. And I agree with having the legislation move forward on that. I've seen intellectually acute senior residents that receive mail requests. That's one of the issues we saw. Things that come in the mail from the church, from political associations, and they're writing checks out and sending them off to these people, and then they don't have money to pay their bill. That's a big issue because they love getting mail. Somebody's sending me something. They must like me. I'm going to send them some money. That's a big area of exploitation with seniors in personal care and assisted living. You know, we had a former accountant that all his money went to a political committee, and I won't say which one, but he had no money to pay for his bill then. He didn't get along with his son. We had to bring in his son so he could take over his finances. But he was an intellectual person, but said, they need my money and I'm sending it to them. So he had no money to provide for his care. But as I said, as a senior as myself, we do have a right to make bad choices. There is a difficult balance between legislation, regulations, and resident rights. In this regard, who would file the charges for prosecution for financial exploitation? As they said before, is the family going to come forward? Is the resident going to come and file charges against their daughter? Is it up to protective services to file those charges? You know, if it was the family member, the senior's not going to file the charges against them. Remember, we are dealing with adults here and not children. Seniors have provided, through their work and dedication, benefits for all the seniors of the Commonwealth. Protecting their hard-earned finances is an important right, and PALA supports including financial institutions in the fight to prevent financial exploitations of seniors. It is unfortunate that elder abuse exists in our country. Gone are the days of respect for your elders and their contributions to society in their lifetime. As technology continues to advance, the option of using patient care monitoring devices has increased. There are guidelines in House Bill 397 for the use of monitoring devices. Currently in personal care and assisted living, we have an interpretation of the resident's right to privacy regarding, as we call them, granny cams. They don't even have to tell us they're installing them. We are in the process of working on different interpretations with our regulatory agency for that. Because, you know, let's go back to some of those family situations. The brother doesn't get along with the sister. He thinks she's stealing jewelry from mom. I'm going to put a camera in. Who is the representative that is permitted to put that camera in? It should be up to the resident to decide to put that camera in. And are you okay with a son in California watching his mother get dressed on his computer, and all his employees standing around, or in Walmart with their smartphone watching his mother get dressed? There's no prohibition for that. It can happen. So we have to look at the residents' rights and what's happening with those videos. Where are they storing them? Can they post those as we go into the other House bill? You know, it's their property. Are they going to be able to post those anywhere they want to? So we have to be considerate of the residents' right, and it should be their choice, not the representative, unless they've been deemed incompetent. Then it should be the residents' choice to have those cameras. So how many of us have checked our smartphones during this meeting? I'm sure everybody's had them out. It's a way of life. We all panic if we walk out from our house without our phones. But it's unfortunate we must have legislation to regulate the use of digital images of care-dependent persons. But I do support that. I mean, when this first came out, I said to some of my former administrators, this is a great way to tell those staff members to keep those cell phones in the car and not bring them into the building, because it's an issue. People are constantly checking their cell phones. You know, but again, let's look at some of the definitions that are with this. Who is the caretaker? And in here I have the definition of a caretaker that goes back to Title 18. It includes a family member. So is the family member that takes a picture of mom in her nice new pajamas and sends it to her brother, and he thinks it's inappropriate? I mean, we have to kind of pull together what is meant by indecent. You know, it's between the sender and the receiver as to what's going to be indecent. Posting on social media should be definitely prohibited by even the family members. The resident should have to comply with that. So, you know, as technology continues to advance, legislation and regulations will need review to adapt to all these changes. I think the bill is good, but we need to look at them a little bit closer. I'd just like to close by reiterating, we all have a right to make bad choices. I'm a senior, I have a right to make a bad choice. We are not children, we are adults. I don't consider myself an elder. But there's a fine line between protection and regulation without compromising seniors and their residents' rights. Let's work together on eliminating elder abuse by getting to the source of bad actors, including family members, who take advantage of our senior population in the Commonwealth. Thank you.
Chairman Day, Chairman Samuelson, and the members of the committee, thank you again for having us and the opportunity to testify before you and discuss elder abuse. I have a very sore throat, so forgive me if I'm scratchy at times. No, I'm good, thank you. I just want to apologize in advance. So again, I'm Tasha Cooper. I'm the CEO of Home Care Associates. Home Care Associates is a worker-owned home care company located in Philadelphia. We provide caring, reliable support to individuals in their home. Our aides are trained and certified paraprofessionals. As a worker-owned cooperative in Philadelphia and Pennsylvania, HCA's home care aides have an important stake in the company and their futures and take great pride in providing excellent care to each of our clients. Our agency serves about 200 seniors in the thank you very much, in the 5 southeastern PA counties. Our goal is to keep each member active in their communities and in their neighborhoods. I'm also a member of the Pennsylvania Home Care Association, a statewide membership association representing more than 700 organizations that bring medical care, personal care, and end-of-life care into thousands of people's homes every day across the Commonwealth. I'll begin today's discussion by providing you with a brief overview of home-based care, what it is, who we serve, and then I'll discuss the issues concerns related to elder abuse. Finally, I'll discuss the challenges faced by home care providers in providing care to Pennsylvania's elderly population. As a member of the Pennsylvania Home Care Association, we know that there is no place like home. Most people want to age in the comfort of their homes and communities and receive care and supports at home. Pennsylvania has stated by the members of the panel, Pennsylvania has one of the fastest growing aging populations in the nation. Many individuals need help to remain active and independent in their communities. People want to stay at home, in the neighborhoods where they were raised, with their families, where they visit their favorite coffee shops, and know their neighbors whenever possible. Our older adults should not be relegated into institutions if they are otherwise able to remain in the community. The Department of Health, which licenses all home care providers, reports that there are 2,799 non-medical home care agencies providing assistance with activities of daily living, 607 home health agencies providing skilled nursing services, and 186 licensed hospices in Pennsylvania. This does not include hospitals and skilled nursing facilities that also provide care to thousands of our seniors. There are 2 models of home care and the provision of personal assistance services in Pennsylvania: the agency-based model, which is Home Care Associates, and the consumer-directed model. Under the agency model, a consumer hires an agency like mine. We hire caregivers, provide training, and manage their care. Under the consumer-directed model, the consumer manages his or her own care, hiring an individual caretaker that they often already know. Both models are critical to serving the growing personal care needs of Pennsylvania seniors. But it's important to understand the differences between the two. Elder abuse remains an important issue in Pennsylvania and nationally, and one we must all take reasonable steps to prevent. In 1987, Pennsylvania's Older Adult Protective Services Act became law. Among other things, OPSA required background checks for caregivers and prohibited the employment of certain agency caregivers who had been convicted of specified lists of crimes. In 2015, Pennsylvania's Commonwealth Court ruled that the lifetime employment bans in OPSA were unconstitutional, and that they did not allow for waiver process for someone who had been rehabilitated. The court focused on the consideration of factors such as the nature of the crime, facts surrounding the conviction, time elapsed since the conviction, the evidence of the individual's rehabilitation, the nature and requirements of the job, and the performance of individualized risk assessments, in determining whether someone should be able to provide personal care as an agency caregiver. Since that time, a number of OPSA bills have been introduced in an attempt to respond to the public court's concerns, and also to expand upon protections for seniors, prevent financial exploitation, and add additional requirements for agency caregivers. It is important to note that many of OPSA's amendments would not apply to the consumer-directed model or consumer-directed caregivers. Despite the fact that they make up a significant percentage of home care providers in Pennsylvania, this would be family care providers typically, the son, the daughter. Despite the fact that they make up a significant percentage of home care providers in Pennsylvania. For example, although background checks are required for both agency and consumer-directed caregivers, any employment bans being contemplated by OPSA amendments will apply only to the agency caregivers and do not apply to the consumer-directed caregivers. Under the law as it stands today, the Department of Aging is responsible for administering OPSA and providing protective services through the Area Agency on Aging. A year ago, the Office of the Inspector General released a report that noted there was a 40% increase in elder abuse that could get worse as the baby boomer population continues to age. The report also identified four major areas of concern: the importance of conducting timely in-person interviews with seniors to follow up on reports of alleged abuse, the need for frontline AAA staff to quickly and accurately categorize reports of need to determine appropriate next steps, the necessity of adequate training for those frontline intake staff and for those supervisors and others participating in the protective service system, and the necessity to monitor and review the triage of incoming reports of need for uniformity and accuracy. Today, your committee is receiving testimony regarding a package of bills intended to address elder abuse. PHA appreciates your commitment to protecting the individuals our members serve. The concept of financial exploitation has become more and more prevalent in recent years. We hear stories about seniors being targets of Social Security and IRS scams on a regular basis. We've read about grandchildren stealing from grandparents and more. PHA strongly supports legislation to strengthen financial exploitation laws and to better protect our seniors. Chairman Day's proposal would create a private right of action against individuals who financially exploit seniors. A similar provision is contemplated in the current OPSA legislation. Additionally, Chairman Day's legislation creates a senior trust fund that will help senior victims of financial exploitation recover lost income. As this particular bill moves through the process, PHA welcomes the opportunity to act as a resource for this committee. Additionally, Representative Culver has introduced a bill that would create the crime of financial exploitation in the Crimes Code, grading it as a felony and creating concurrent jurisdiction with the Attorney General's office. Legal deterrents such as this prioritize our seniors and are intended to keep unscrupulous individuals from preying on our most vulnerable. I hate to use the word vulnerable now that I've heard your testimony. So I would say on our elder citizens. Although the broader OPSA bills are not the subject of today's hearing, PHA hopes to be a continued resource of conversations continue regarding OPSA, We have long supported stronger protections for Pennsylvania seniors and urge this committee, while it's considering OPSA amendments, to also ensure and protect access to quality care for seniors in need of care across the Commonwealth. It is important for this committee to understand that current OPSA proposals would significantly change the background check process, timing, hiring rules, and employer protections. They also would, for the most part, apply only to agency caregivers and not to the consumer model. I cannot overstate the workforce crisis as mentioned by others in the direct care worker field today. We struggle to recruit, hire, and retain quality caregivers. And it is absolutely critical that any changes to OPSA do not result in unanticipated, inappropriate obstacles in a way that would negatively affect our ability to provide quality care to our growing senior population. As Pennsylvania continues to age, the demands for home care continue to increase. There simply are not enough qualified care workers to fill the shifts and meet the demands of today. The needs are only increasing. As we move towards June and the budget out, we'll also note that part of ensuring our vulnerable populations are safe is responsibly funding the programs that are in place to protect their health and welfare. Please consider an increase in funding to the Protective Services Program as well as reimbursement under the Medical Assistant Program. At about $11.50 an hour, the average wage for Pennsylvania's direct care worker, this does not keep us competitive or meet the needs of today's marketplace. We are only as strong as the resources we have. In conclusion, I would like to commend Chairman Day and Representative Culver for their proposals to combat financial exploitation We need to protect our elderly and ensure that they maintain their dignity throughout the aging process. I thank you again for this opportunity to address the issue of elder abuse today. We need to do our best to protect those who cannot protect themselves and ensure that they are able to maintain their dignity and have access to quality care.
Thank you so much. I appreciate all of your comments today, and I want to start with Zach. You mentioned, and I want to just confirm the amount that you all have participated in what we've been trying to do in the last 2 months to gather information. I just want to thank you, and I'm very appreciative of that. Your comments on 397, I'm going to ask you if you could provide, you said some of your members have policies on video surveillance, and if you could find and provide, either provide policies or if the association, group that you represent wants to kind of bring a couple policies together for a model policy.
Sure.
It's something that an association might work on anyway as an association, right?
Yeah.
So I'd like to see that. What I'm interested in is I think the government's role is what are the minimum standards is what we would put into law. So if you boil it all the way down to a minimum policy requirements that all reasonable, rational people providing the services that your members do should have in place, I think that would be great guidance for what we do with 397. Also, and I appreciate your comments, always so outstanding and bring so much real world and life experience to what we're trying to do. You talked about the same thing and a lot of objections. If you try to address how would you address those objections, that can help us move towards and actually present. If we did do it, we'd want to prohibit this, prohibit that, or whatever, or require this type of lay of the land. Sometimes people are, don't want to do that if they oppose something and just let us work with it and flail around. But sometimes out of that comes bad legislation because members, and I represent a lot of members who've been talking to me about they want to do something in this space. Particularly Representative Mosser. So sometimes by creating something like that, it's illustrative in itself of all the concerns that you have. So I would ask you guys to kind of work together on that and come and provide that to the committee.
And
Mark?
Mr. Chairman,
Yeah.
if it would be helpful, since this bill was introduced, we have reached out to our other state affiliates to see what's working in other states. The last time we checked, there were 6 states across the country that have also developed and implemented video monitoring laws. And so we've reached out to see what has worked, what hasn't, and I can also report back to you on that as well.
And I mean, it's just my kind of a lay position. It's my feeling that we should be able to allow some consumers that have families, when we go through the list, Margie, that you talked about, respecting, what is the phrase I learned from you guys about the presumptive, the patient's, how the patient would have decided for themselves if they were competent? What is that phrase? I forget that phrase. Sorry. Nobody else does? I don't feel bad. I don't feel bad. But there's an industry standard where caregivers try to, even if someone is deemed incapacitated, try to make the decision that they would have made, right? So, and I want to keep with that. But anyway, the point I was trying to make is that I think there's a place to be, and we can address each one of those concerns. So maybe it's very narrow, but that we do give the public an opportunity that if you check all these boxes of, the patient, the family, all the caregivers, all the stakeholders and interest in that person, I think there should be, allowed under law that an institution can't just say, no, you can't do it. So that's kind of my thinking on it, and that's why I want to ask you for that. Margie, you talked about elder abuse definition. I think that's outstanding testimony to bring to our committee, and we'll have to look at that. And Ms. Cooper, you mentioned, should it apply to consumer-directed caregivers? or actually, that's my question to you, is you mentioned it doesn't, and I'd like your input, maybe later, or today if you want to, of whether it should apply to those people too. It seems like it should to me, and I would want to get your reasons and rationale behind that. So with that, I'd like to continue to keep the hearing moving along, just give you some feedback, and I'd like to go to our minority chairman, Chairman Samuelson.
Thank you. Just a quick question for Ms. Cooper about that point that Representative Day just mentioned, whether employment bans in proposed OPSA changes should apply to not only the agency-based home care, but also the consumer-based home care. I'm trying to get a breakdown of what percentage of all the folks in Pennsylvania who utilize home care, what percentage falls into each category.
I can't answer.
Oh, yeah, turn that on, and, yeah.
I can't answer to the specific percentage, but I'm sure we can get you that information from the Home Care Association. So I'd be happy to get you that later.
You have a general sense, is it about half and half, or do most people?
My sense is that a little bit more receive services at on the consumer-directed model than the agency model.
Okay.
The agency model, so the employment restrictions don't apply to the consumer-directed model. Oftentimes, they are family members, neighbors, relatives, and although there's a now criminal background clearance that is required, one can still choose to use that person, whereas in an agency model they can't. So for us, really, the issue is twofold. It is the fact that these rules don't apply to the consumer-directed model, and to us that doesn't make sense at all, because they should be held to the same standards as everyone else, and the rules should be the same across the board. Not because we think that because we're having a tantrum, but because of the safety issues related to the person receiving the service.
And am I correct that in both cases, agency-directed model or consumer-directed model, public funds could be involved? You might have an aging waiver, you might have the area agency on aging paying, so the taxpayers could be involved in the payment.
Correct. Yes.
Thank you.
Great. Next, we'll go to, for questions, Representative Wendy Thomas.
I have one question, but I want to follow this because you guys made me think of something else.
Sure.
So consumer model, just to be clear, I need care. I want my child to do it. My daughter's coming in, so I apply. This really has to do with money, as I understand it, right? So in order to get paid by Medicaid, they would have to get a clearance, even though it's my son or daughter. That's what we're talking about.
Correct.
Okay.
But the list from the Department of Aging, that the exclusion list, the list of possible crimes is we can't hire certain people who are on that list, whereas if it was a consumer-directed model, it wouldn't matter.
Even though we pay them with state-funded
exact
dollars.
same funding.
Okay.
Yeah.
Thank you for that clarity. The original question I had, I think, Zach, was more to you, and around the chairman's beginning. If you would provide us that, and if you would also provide us with any background on what they've done to address privacy issues. So I worked in healthcare, and HIPAA is a huge, enormous rule. And besides just common decency privacy concerns, which I think we all understand, there are also some greater. So while they might not be clearly in the legislation, just having some backgrounds on what's been debated and thought through would be helpful, so we don't ask those questions. Thank you.
Of course. Great, thank you so much. Next, we'll go to Representative Pam Delisio.
Thank you. Just one question. I've heard both from Margie and I think from Denise as well that the majority of the complaints from abuse are related to family-related caregivers. But and we can only deal with what we're told. I understand that. But I actually wonder if that's the difference between, what's the difference between what happens versus what is reported. So, these callers that are much harder to track down, who are scamming people via Social Security, Western Union, email, all this other stuff, my guess is that older adult in those situations who actually get scammed, and I know of more than a few situations, are very embarrassed when that comes to light that somebody just got something over on them, and they're not going to volunteer too readily to their kids or to an agency that they just lost $2 or $3 grand because somebody called to say your grandchild is stuck out of the country in the Philippines and come down to Western Union and, send over, wire over $2 grand. So I think those don't get reported. And you may say, well, what can we do about that if they're not reported? And I think it goes back to this real need for some serious education of consumers so that when that does happen, give them a comfortable space to feel like they can absolutely report it without feeling kind of silly about it. And also in that education to be telling them that, I know an instance once where somebody got an email, and the email is written in such a way that she firmly believed that the person who was referenced in the email was somebody she knew, and in this case was in London. And fortunately, in the 2 instances where this happened in my own family, they called me first to say, I'm concerned, or I'm about to do this or something, and I'm like, no, stop, don't. And it was very hard to convince them it was a scam because they're like, well, how did they get my email address? How did they get my information? So I think then, I'm not sure that necessarily that the family caregiver are the most complaints. They're the most that we hear about. And those others are still very much out there. And I think we would be remiss if we just thought, since we're not getting complaints, that's not an issue. I think it's very much an issue. I think it's grossly underreported, and maybe our only opportunity to do that is then education. So I heard those comments twice today, and I don't want to forget this other piece.
Representative, can I just make a comment before you guys, because I want you to include this? So in going down to Western Union and that kind of thing, I think we have to include in that I can Venmo somebody in this room money right now if I want to.
Yeah.
And
New way of doing it.
yeah, and so as we think about it,
Wait a minute,
there's
that's an
not much to
elder
go.
committing,
The
almost elder abuse.
committee. But I just want to include in your comments that it's becoming easier and easier to transfer financial money. And so if we're going to think about solutions for that and ways to address that, we need to, I'm sorry, just wanted to tag on to your thought.
Yeah, and I just wanted to say, because personal care and assisted living is private pay, we probably find that out sooner because they don't have the money to pay their bill. Where if they're on, Medicaid, I know they do research, but for us, that's our first thing. If you're behind 2 months, then we're sitting down and saying, what's going on? And a lot of times they'll open up at that time with us.
But I think, as Margie said, when the family has taken assets or taken income that's supposed to come to the nursing facility, while we try to say, hey, this is elder abuse, we're basically told, try to collect it like anybody else would try to collect money. Go to the magistrate, try to sue the resident in your building or the family member. It doesn't work. And frankly, at least in those illegal transfer of assets or uses of monthly income that should come to nursing facilities and then don't, there really is no way for the nursing facility to get those funds back, and we're on the hook. And it just makes the problem of lack of Medicaid funding even worse when you're on the hook to provide a lot of private care for no funding.
And the other thing that's out there is the veterans benefits. There were scammers out there saying, I'll help you hide your money so you can qualify for the veterans benefits. How is that fair if you have the finances? Okay, let's go give these, and I'm sure you deal with that too. There were scammers out there saying, we'll hide your money and now you'll qualify for all the veterans benefits. That's not fair either.
I appreciate your comments, and I did write down here, inappropriate transfer of assets was the topic that you talked about. And just for, our viewers and the public here, is we have a compact where we as policymakers make a decision that people going into this situation should contribute part of their assets toward this, right? And then the state will step in, or a government agency or even nonprofits absorb some cost. And it's part of the contract or the compact for people entering into this. So people actually moving their assets to avoid it, you said to the tune of $631 million per year. I think, was that the right,
Well,
was that
that's
was
the
that a
gap.
different?
Yeah, that's
Okay.
different.
That was
Yeah.
the adequate funding component,
Correct.
right?
Yes.
So I had those comments written down, and I just want to say, continue to make those arguments. They're hard for you to make, I think, because sometimes you or maybe members of an association feel like, you know, they're just making an argument to take someone's assets, and that's really not what's happening. Is that in many cases, I'm sure some people can put assets in until they can't and they don't have it, and then they're taken over by the Commonwealth or other agencies. So I appreciate that. Our final question right now will come from Representative Frank Ryan.
As you know, we've had a number of these discussions about it. Zach, you used a comment that in 3 to 5 years, the financial issues, and you've heard me say the comment in 3 to 5 years, the Commonwealth's financial ship, if not turned around, will be an unmitigated disaster. What I would think would be useful, and to the chairman and minority and majority chair, I'd encourage us to have a separate hearing on the entire issues related to the viability of the long-term care model. And I want to be very candid. I mean, I think it's incredibly important. The perspective that I, as a senior, and I'm not going to say elder anymore, but as a senior, particularly someone who walked across the United States when I was in my mid-60s, we all have to accept responsibility, seniors and others, about relative to the cost of this system. So, Zach, you used 3 to 5 years. I'm going to ask you two very pointed questions. Is the current model of reimbursement in such a way that you can ensure the viability of the industry long term, number one? And number two, the more important issue in my mind is the way that we have our tax policies in the Commonwealth established actually causing a grain of the Commonwealth that's more severe, that will exacerbate your 3 to 5 year program, that will basically say that it's not 3 to 5 years, but might be 2 to 4?
I think it's, to answer your first question, no. So the way things are now in terms of Medicaid reimbursement, and I hope that I'm getting to your question, in 3 to 5 years, this continuum will no longer be viable. And I don't know that it will even last that long, because Ann talked about a workforce crisis. I mentioned Medicaid reimbursement. I talked about the legal climate, the regulatory climate. And again, with Pennsylvania being the third oldest state in the entire country, that's really frightening to me as someone with a grandfather in a nursing home, with someone whose mother, aunt, and 3 cousins work in long-term care. I'm worried that this system will not be able to sustain itself for the next few years. And, you know, you only have to look at Pennsylvania's long-term care system over the last 2 or 3 years, where we have seen extreme volatility in the market. We've seen sales, we've seen reorganizations, we've seen changes of ownership. And then you go around the country and you look at states like Connecticut, Massachusetts, Texas, Wisconsin, Oklahoma, South Dakota. You see those things, but you also see closures. In Massachusetts alone, last year, 35 nursing homes closed. So I look at a state like Pennsylvania, I don't want that to happen here, and I am afraid we are already on that path unless we do something about it.
Yeah, I just want to echo the comment. It's the last issue I'll make on it. We, and I'm now speaking as someone who's over 65, we in my age group have to recognize that if we don't reverse the trend that the Independent Fiscal Office indicated, that younger people are moving out of the Commonwealth, if we don't reverse that trend, your industry is a failed business model.
Yes.
I have worked for decades doing turnarounds of financially troubled companies. This organization, and I was with a hospital group that got rid of all of our senior care facilities, was we recognize it's a failed model under the current reimbursement. And it can't be, because no matter what happens, those costs are going to be there about who pays it. And you had some good points. Margie, again, I appreciate your comments, but I truly do. You do have great comments. But for those of us on this committee, we cannot just sit back and keep putting Band-Aids on this. This requires some incredibly painful, difficult, honest discussions with seniors caregivers and providers and hospital groups, or this thing was going to fail, and time is no longer on our side.
And Frank, I'd be remiss if I didn't mention, Frank was great to come out to one of our communities. In Pennsylvania, personal care has SSI. It's $37 a day. And I brought him to a community that had over 60 people there. You can't provide care for $37 a day. And that's the only financial money that's available for low income to live in personal care. So I appreciate him coming out and seeing what only $37 a day can do.
From a home care perspective, the issue of reimbursement is a big one. We are reimbursed $19 in Philadelphia, $19.52 per hour per hour of service. In Philadelphia, there's a fair wage law where the city is promoting a $15 an hour minimum wage for those who contract with the city or those who have more than 3 locations, which is great. We'd love to be in a position of paying our aides more. We believe that they deserve more, but we just can't. We're competing now with not only the number of home care agencies that are opening because they think they can make a quick buck and quickly close and realize they can't, but also now McDonald's and Target and other places like that, where they see home care, this job is one that is not, that is valuable in terms of the work that they do and the contribution to the community, but one where they cannot take care of their families. And so they have to make a choice as to whether they're going to do this work or not. Fortunately for Home Care Associates, we've been around for about 25 years, so we're a viable company. But honestly, in the last 3 years, we have not profited at all. And it continues to get worse with regulation and legislation that's passed, requiring more and more of us. In some cases, we agree. In other cases, we don't. Now with the transfer of services or contracts from Office of Long-Term Living to the managed care organizations, there are even more requirements that now we are burdened with that cost us a lot of money. So we are very concerned about our ability to continue to provide quality service in the state of Pennsylvania. It is a big issue. I don't even know how we're going to survive next year and the year after, and we feel very good about the quality of care that we provide and our contribution to the people in Philadelphia who need those services. That, and can I also say, on top of that, I want to share one other story. We have just created a fund. The fund is because that we created out of pocket in a struggling, in a struggling environment, is because we do have seniors who are scammed. We have seniors whose son comes in at the beginning of the month and drains the account, and we have aides who go in every day who cannot just say you get $10 or you get this, but you have no food in your house. The aides are coming out of their pocket at $10, $11, $12 an hour to provide washcloths and food and other things for seniors who are being scammed or whose families are taking advantage of them. And that kills us to know that we have employees who are coming out of their pocket because they care. So as an organization, we've created a fund to relieve our aides of this obligation that they will do. They will take care of their consumers because it's not fair. They're already underpaid. The reimbursement is already low, and now we have ongoing continued regulations that cost us even more money. And now we have the issue of people being scammed and the population getting bigger and bigger. And, you bring up the issue of reimbursement. It is worth mentioning that this is not going to get better. And for quality agencies who have no control over these issues, this is something that the committee should really consider. There needs to be some additional support for agencies who are really out there doing good work.
You guys have done an outstanding job today, and I want to thank you very much. We have a lot of members here today and on our committee and throughout the House of Representatives who care deeply about these issues and work with people in their districts all the time. I want to remind people that if you do see elder abuse, I'll put this on our video, just to call this number and report it. And we're going to probably work more in the future on some of the things we talked about. Suggestion from Representative Ryan, I appreciate that. All the questions of all the members up here in testimony today have been absolutely outstanding. I want to take a quick moment to thank New Hope Fire Company again. We're actually going longer than we told them we would be here. So I want to just thank them again for their indulgence for the length of our hearing. I want to thank our team here, our audio and visual team here, and also all the people that have attended here today. Chairman, do you have anything you'd like to say to close up the hearing? Thank you all very much for your testimony today, and continue to be engaged with our committee. Thank you.
Thank you.